Good afternoon, everyone. Thank you very much for joining this afternoon's virtual roundtable. I'm just going to start the session a little bit early so that we can run through a couple bits of sort of housekeeping just before we introduce my fellow panelists. At the same time, sort of run through what we're going to do today. So just to do a little bit of housekeeping as we get started. As with all of these virtual roundtables, the idea is that we have a free exchange of ideas. All the participants, the panelists, will sort of express their own opinions on the fact patterns that we're running through. But the idea is that this is not and doesn't constitute legal advice, and that you shouldn't be relying on this as constituting legal advice going forward. But it's just a sort of sincere discussion between professionals dealing with the matters at hand in terms of these scenarios that we set ourselves. So with that admonition, I'll run through just some of what's coming after this Malaysia Private Client Virtual Roundtable. Now, there is a program that you would have seen being advertised on social media, and this deals with the governance and succession, family business, family office. And this is comprised of 6 separate talks spread throughout August and into September. I'll just take the opportunity just to introduce some aspects of this. You'll see also that I've put on the chat a link to the registration page for this rather lengthy program. And you'll also see all of the various participant law firms that are involved. And we're also grateful to be sort of invite Monetary Authority of Singapore to also participate in these talks. Now, the first one is next week on the 26th of August, and this deals with just setting the scene for the business families within the region, the emergence of the family office, and basically looking at some of the problems that the business families have encountered in trying to effectively transition their wealth across generations. And we sort of go through a sort of framework that the families can adopt when they're considering different options going forward. But it's really mostly about setting the scene, talking a lot about the MAS initiative here with training professional advisors so that they can better serve some of the families on things like family offices. The next day, so it's a double header, we're then going to look more at the technical side of how to sort of solve some of these business family issues. And we'll look at critically at shareholder agreements, share class rights. We'll look at the use of trusts in this and whether or not the family charter is right in all circumstances. We then move on to regional talks. And here I'm inviting regional senior counsels to really help us to understand what's going on within for instance, the India or Indonesia business family market, what's going on with respect to the growth of family offices in these markets, and what role can Singapore play in these emerging or regional markets. And so the first of the regional talks will be India and Indonesia. And then this will be followed in the following week by senior counsels in the Philippines and Japan, who will talk about the emergence of family offices in their respective countries, as well as the struggles of the business families to find a correct footing to transpose their wealth across generations. Well, then within the regional talks, we'll then sort of wind up with Malaysia and Thailand, and we'll do the same approach, but here we're just trying to find what are the business family dynamics in the Malaysia and Thai markets, and also what is the demand for family offices, as well as international family offices in the guise of the Singapore single family office. And so it's designed, these regional talks, so that attendees, participants can have a good reference point on where the markets are and what's trending within those markets, as well as understanding the limitations of whether or not a Singapore single family office can actually be used in fact. Then we will conclude the sessions with a review of the single family office in Singapore, looking critically at the correct way to structure, whether you're using corporate or you're using a trust, what are the options that the families can sort of use, and looking at what are the pitfalls in sort of malstructuring these single family offices going forwards. And there we talk more about the difference between a family office and an investment office and a multi-family office, and try and understand the dynamics of the marketplace. And we'll again invite MAS to contribute, as well as sort of one of our co-hosts, which is BDO on the tax side. So it's a significant program. It will take basically the whole of September to get through. It's 6 talks commencing next week with a double header on Wednesday and Thursday. Okay, so coming back to today's virtual roundtable, the Malaysia Virtual Roundtable. I'll introduce my sort of co-panelists, and I'll go through each in turn just to talk a little bit about their background and what they're doing, just so that in case you haven't come across these prominent practitioners before, then we'll have an opportunity for you to understand what they're doing. So the first I'll talk about is a good friend of mine, Farah Crosby. Farah is obviously CEO of Labuan IBFC, a wholly owned subsidiary of Labuan Financial Services Authority, which is the statutory regulatory authority for Labuan International Business and Financial Centre, under the purview of the Ministry of Finance Malaysia. Labuan IBFC Incorporated serves as the jurisdiction's official market development agency. Farah is a seasoned strategic communication, market development, and financial services professional with more than 25 years experience in wholesale financial services, putting in good stead to position and develop Labuan IBFC as Asia's go-to mid-shore financial intermediation center. Farah is formally attached to the Asian Institute of Finance and Bourse Malaysia, Malaysia's national stock exchange, and she has served in numerous senior market development and strategic communication roles. And of course, as we've all seen, Labuan has gone from strength to strength over the years, and a lot of that can be attributed to Farah and her team and all the hard work that they've been doing. We'll also be joined by Go Kyan. Go Kyan is with the Sheeran Dillamore & Co. partner with, and heads the Tax and Revenue, Private Wealth and Family Business Practice Group, with more than 23 years experience advising all aspects of tax and revenue law, including income tax, corporation tax, real property gains tax, double tax treaties, Labuan business activity tax, and Labuan companies, Labuan partnerships, Labuan trusts, and Labuan foundations, and asset protection planning. Kim has appeared extensively before the Special Commissioners of Income Tax, the High Court of Malaysia, the Court of Appeal, as well as the Federal Court for Tax and Revenue Cases, an extremely experienced practitioner. And then finally, we've got Dominic. Dominic is a regular on the virtual roundtables, and as we probably all, if you've tuned into these things before, then you'll know that Dominic is responsible for Henry & Partners operations across South and Southeast Asia, and now latterly the UK. Dominic is a private client specialist in residency and citizenship by investment planning, and regularly advises high net worth individuals, their families, and advisors across Asia, targeting countries that are deemed most attractive to wealthy clients in terms of mobility, security, privacy, personal tax, estate planning, as well as lifestyle. Dominic is also a member of the firm's government advisory practice, providing strategic advice to governments on the design, implementation, and promotion of investment migration programs. So there's our panelists for today, and of course yours truly. Okay, so for today, if I can run through the agenda, as with all virtual roundtables, we will start off with looking at different fact patterns dealing with domestic cases, and then looking at foreign cases. In this case, the domestic case will look at migration planning, matrimonial property, divorce and succession in the context of a Malaysian domestic family. We'll then look at the foreign case study, and we'll look at a family emigrating or moving from Hong Kong to Malaysia, the matrimonial property, divorce and succession interface when they do that with Malaysia. Okay, so domestic case study. As usual, we'll build up the fact patterns so that we can then ground the discussion to follow. And here we have Richard, who is a Malaysian resident domiciliary citizen. And he has property, real property, cash, as well as investments in Malaysia. Richard is married to Isabel and has a daughter, Sophia. From a migration standpoint, Richard is interested in two particular sort of topical and popular programs for domestic relations, which is the UK and Australia. The questions that I would ask on this in terms of the UK immigration options is the options that we have for Richard to consider, the due diligence process that's involved in both of the UK, in respect of the UK program, the costs and the investment required, as well as the application time. And I would ask Dominic if he could please sort of help us with understanding from the UK standpoint what's Richard going to be in for when he's looking at this as an immigration program. So Dominic, I think you're here.
Zach, yeah, I'm off mute. Good afternoon, everyone. Yeah, so when we look at the Malaysian market, so from our perspective, there's two sort of interest groups. There's Malaysians in Malaysia who, of course, are not allowed dual citizenship. So very much there's a lot of interest in residence by investment and the various options that are available around the world. And certainly where we see significant interest from our clients that are Malaysian in Malaysia is often into Australia particularly, and also in the UK, where probably education is a bit more of the driver there. And then just as a quick side note, there are of course a lot of non-Malaysians in Malaysia who are also interested in these programs, but also may be from countries, or they may hold nationalities that allow dual citizenship. And then of course some of the other citizenship by investment programs that are available around the world might be interesting for them. So we'll touch on a little bit more of that later. If we look at the UK, as I said, the big driver for families looking at the UK, particularly from Asia, is often around the ability of their children to go and study in the UK. The UK has a number of options available. Of course, there's the typical student visa route. And if it's not education, there's of course, skilled visa routes as well. But from our perspective, we only really focus on those investment migration programs that are available around the world, and also in the UK, where if you meet certain financial capacity and due diligence requirements, you're able to invest sometimes into a business or into some form of investments in the UK, and with that you can get residence in the UK. So by far the most, I would say the most straightforward route into the UK would be the investor program, the Tier 1 investor visa. And this is typically for an applicant that is looking to invest at least £2 million into this used to be able to go into government bonds, which was definitely the preferred route. But the Home Office recently changed the requirements around that. And so the £2 million now would need to go into UK registered actively trading companies. So that can be corporate bonds or shares, typically in an investment account under their name, which they would need to hold for 5 years. And after 5 years, the applicant and their family can acquire permanent residence in the UK, which is known as indefinite leave to remain. It is a tiered program. So the £2 million investment gives you eligibility for indefinite leave to remain after 5 years. You can invest £5 million and get permanent residence after 3 years, or £10 million and be eligible for permanent residence after 2 years. The UK program, though, does require you to actually go and live there in order to earn that permanent residence. So a lot of the programs we work on around the world, the physical presence requirements are, limited to none. But in the UK's case, even if you're investing these amounts, most of our clients from Malaysia, the goal is to get permanent residence there. And if they want that, they would have to spend effectively 6 months in the UK in each of those 5 years. So quite an easy thing to do if the kids are studying there. But depending on the family structure, a lot of our clients in Asia can't afford that amount of time outside of their home country for various reasons. So main focus is really the Tier 1 investor visa. There are two other options which I'll just briefly mention. One is the Innovator program. So this replaced what was known as the Entrepreneur program a few years back. So the Innovator program is for an applicant that's actually looking to start a new business in the UK. Not so straightforward. There's a number of registered endorsing bodies which would need to review the applicant's business proposal and decide whether this business that they intend to bring to the UK meets various tests around innovation and viability and scalability. But if you're going through that Innovator program, you are eligible for that indefinite leave to remain after 3 years. and the minimum investment there generally starts at only £50,000. So depending on the client's profile, also interesting in certain circumstances. And then finally, there is also the overseas business program, which is really for a representative of an overseas business. So the main applicant would need to be a senior employee of an overseas business, and that they would look to be coming to the UK to set up a branch or wholly owned subsidiary of that business. And again, with that, they can get residence. And then the final one, which is not really an investor visa, but quite popular in Asia, is just a simple spousal visa. So, you know, a lot of we find a lot of expats that have come over earlier in their careers, and they've sort of built a family here in Asia, and potentially the spouse is not a UK citizen, but if one of the spouses is a UK citizen, it's possible for them to get the spouse visa and move back into the UK as well. So just in a quick nutshell, so those are pretty much the immigration options. Look, the due diligence process is pretty standard, as you would expect. Certainly on the Tier 1 investor visa, a lot of the AML and checks are done by the bank. So one of the changes that came in around the due diligence was it's very clear that you have to show that, you know, the clear source of those funds, and typically the 2 million that's going to be used to make the investment would need to be sitting on an account for at least 2 years prior to the submission. The cost of the investment, I think we've gone through, and the application time can also be quite quick. So the initial entry visa can be obtained in as little as 4 to 6 weeks. But of course, if the client's looking to go through the innovation, where there's these endorsing bodies that need to take a closer look at what this business is, then the process can get a bit longer. But you're looking at anywhere sort of all in from 3 to 6 months for the process, and relatively straightforward.
In terms of the due diligence, they look at the source of funds for the investment, but then they also look at the source of wealth generally of the applicant. How far do they actually go into a full AML review as if they were immediately high-risk sort of customers? How does that work, Dominic?
So, I mean, in terms of the investor visa, obviously they're typically the 99% of the clients would do it through an investment account with a local bank in the UK. So the bank would typically be covering off all of the AML checks. In terms of the process itself, you know, the applicant always has to give police clearance certificates. There's the normal sort of KYC checks that would be done not only by us before we even accept the client, but also by the Home Office itself.
Right, okay. And in respect of the Australian program, again, what are the options that Australia's offering? And then the same, what's the due diligence process look like, the costs and time of application? How does that look as a comparison to the UK program?
Yeah, from a due diligence perspective, it's much the same. You know, clients would always have to provide police clearance certificate. There would be probably a slightly more extensive analysis of the source of funds, and that's also because the amounts that are required for Australia, particularly on the top end, are even higher than the entry level in the UK. Australia, again, as I said, is residence by investment. So both in the UK and Australia, citizenship is possible in the UK after 5 to 6 years, depending on what route they go. And in Australia, a similar time frame, usually after 5 years. But if you want the citizenship, then you've really got to spend physically at least sort of 75% of each of those years in the UK or Australia. And of course, if you're from a country like Singapore or Malaysia that doesn't allow dual citizenship, then it's quite a big decision to make to renounce, you know, the nationality you were born with to take an Australian or UK citizenship. In the Australia program, so we just talk again, Australia has a number of sort of skilled visas, student visa options, but we only really focus on assisting clients with the investor visas that are available. There's pretty much 2 broad categories available in Australia. You've got the business innovation stream, which is known as the 188 stream, and there's a couple of options under that. And this business innovation or 188 visa class is effectively a 2-stage process. So you would make the investment, you would get a temporary residence visa in Australia for 4 years, and subject to certain requirements in terms of the investment and physical presence. After 4 years, you can get permanent residence in Australia, and again, later on citizenship if you qualify. The second stream is the Business Talent Program, which is the 132 subclass of visa. And there it's a direct to permanent residence route. So depending on the client, look, as I said, a lot of our clients in Malaysia as well are not ready to move yet. So the two-stage process is okay, because once you become permanent residents, like in a lot of countries, in order to renew that permanent residence or to keep it, you do have to spend some time. So a lot of the clients are happy to go with the 188 stream, which particularly if you go in on the top end, which is a $5 million investment, then you actually only, the physical presence requirements in Australia are quite low. So depending very much on what the clients, what their timing is and what they can do. Most of the clients, we always say, are cash rich and time poor. So, they have the financial capacity to do these things, but it's not so easy to go and spend, a significant amount of time in the country. But we see now, particularly hopefully coming out the back end of this COVID situation, maybe not quite, but a lot of clients are now looking to just have that plan B in place, depending on how long the current situation goes on, and arguably maybe this is not the last pandemic we'll see in our lifetime. So a lot of the clients are looking at Australia and New Zealand as well. We're not going to get into New Zealand today, but New Zealand has significantly picked up in interest as well. Similar structured programs as Australia. In terms of the investment amounts, so the two most popular programs in Australia would be the investor stream, and then what's known as the significant investor visa stream. So the investor stream requires a 1.5 million Aussie dollar investment into a state government bond, so it's a relatively low risk. But it's only really for someone that's looking to physically move to Australia. So as I said, it's a 4-year temporary visa. You invest the 1.5 million into a bond. And in order to get permanent residence after 4 years, the applicant would need to spend 2 out of those 4 years physically in Australia. So it requires a bit of a commitment in that regard. What is very popular, of course, is what's known as the SIV, the Significant Investor Visa. That's because it's a higher investment amount, but there's no real requirements in terms of the applicant's personal experience or skills. And the physical presence requirements are also very low. So in order to get permanent residence after 4 years under the SIV, the applicant would only need to spend 160 days over the 4-year period. But in order to have that benefit, it requires a 5 million Australian dollar investment. And that's typically into what they refer to as complying investment. So that is 10% needs to go into venture capital, 30% into small cap emerging companies, and then the balancing 60% can go into bank bonds and that type of thing. So it's a different risk profile in terms of what the investment is going into. But there's a number of fund houses or banks in Australia that have funds set up specifically for the SIV.
Right. And you mentioned New Zealand, and just show on the screen some of the other migration programs. What other programs do Malaysians typically look at other than the UK and Australia, or that you've seen trending?
Yeah, so look, the US and Canada is similar to UK and Australia. Still quite popular from an education perspective, but the programs are quite lengthy in terms of the process. So the US has the very well-known EB5 program. That minimum investment went up from 500 to 900,000 US last year. Canada has a pure investment program, but that's currently closed and will probably only start accepting applications next year. Probably the things we do the most, if it's outside of Australia or the UK and Malaysia, Portugal, has one of the most popular programs across many nationalities. It's residents. It's typically a 350 to 500,000 euro real estate investment. It's an interesting investment. Lisbon and Porto and these places are certainly preferred destinations in terms of getting into real estate. And then with that, you're getting a resident card for Portugal. So again, it's that plan B or just an option if I need one. And also the interesting thing about Portugal again is is through this, what they call the Golden Resident Permit program. After 5 years, as long as you can speak elementary level Portuguese, you can also apply for the Portugal citizenship, again, taking into consideration whether your current nationality allows that or not.
Right. And just finally, I think, Dominic, just an update on the MM2H program that Malaysia had in operation for many years. Is there anything that we can sort of report on that?
Yeah, so I mean, the latest update is unfortunately just that it's been suspended while the government reviews a few things. So it's been a wildly successful program, relatively low thresholds to get to obtain it. You know, it's a fixed deposit on a bank account in your name for 10 years. You get a 10-year long-term visit pass, and that fixed deposit can range, depending on your age, anywhere from roughly $50,000 to $100,000. But the program was suspended last month. The government has said that they're going to be doing a review of it. Probably we can expect maybe some changes down the line, but the last indication at the moment, we cannot submit applications at the moment, but the last indications of that, the program will open again towards the end of the year.
Right, okay, all right. Okay, thanks very much, Dominic. I think we'll move on now and look at domestic matrimonial property. So going back to the original fact pattern, where we have Richard and Isabel with Sophia. And what we've got is a spread of assets across multiple jurisdictions. So here we have Richard owning a BVI company, which in turn owns an investment account in Singapore. And then separately, Richard owns land, as well as an investment account in the UK, as well as the domestic Malaysian assets. So what we're looking at is from the context of the matrimonial sort of regimes in Malaysia. It's a few questions that we would ask. Does the concept of matrimonial community property exist in Malaysian family law? Is there a presumption of joint ownership of the matrimonial home? And are pre- and post-nuptial agreements valid in Malaysia? And here I'd ask Kim just to run us through from a Malaysian perspective, whether or not these, how these questions can be answered. So leading off with the concept of matrimonial community property within a Malaysian context.
Yes, good afternoon, everyone. In Malaysia, we don't actually have this concept of community property as such. We don't call it community property, but when a couple wishes to legally separate or divorce, when they go to a court in Malaysia, then the court does have the power to order division of the assets acquired by the couple during the marriage. So from that point of view, it may be taken to be, the same thing. So they don't call it as such the community property, but the court would look at the assets acquired during the marriage and take into account contribution by each of the party, whether in terms of money or in terms of work, and in terms of perhaps for a spouse that doesn't work, caring for the family, all those things will be taken into account in the court making a determination as to how to split the property acquired during the marriage when the marriage breaks down.
Right, and this is effectively a discretionary power.
It is a discretionary power.
So there's not like civil law jurisdictions where there's an automatic sort of division on the marriage, on celebrating the marriage. In Malaysia, really, you look at it after the relationship has broken down and they're trying to divvy up the assets in the divorce.
Yes, so yeah, so they do take into account all these factors that I've mentioned, right. As well as the needs of the children, of course, and the debts of the couple, that sort of thing.
Right, and insofar as the matrimonial home is concerned, this is always a perennial problem when it comes to cohabitees and also with obviously married couples. Does Malaysia rely on effectively trust law to work out whether or not there are actually shares outside of the divorce discretionary powers, or how does it work within the Malaysian context to work out whether or not the matrimonial home is itself owned in divisions?
I think Malaysia follows the English concept of trust law, being a common law jurisdiction. So the trust concept is always there and is always in prevalence. But I think when it comes to things like the matrimonial home, because there is a specific act that we're talking about, which is the Law Reform Marriage and Divorce Act of 1976. So the court and the judge would go in accordance with that act and the powers and the provisions set out in that act.
Right, right. And then this perennial issue of nuptial agreements. And this is something that's recurred across the whole series of virtual roundtables. And we just want to sort of understand from a Malaysian standpoint, what's the status of a nuptial arrangement with respect to a marriage breakdown? Do the courts slavishly follow them, or do they effectively not take them into consideration? What's the position under the Malaysian family law when it comes to nuptial arrangements?
Well, the concept of pre and post nuptial agreements, as you say, is now becoming a lot more common. And in terms of just the validity of those agreements, obviously, like any other agreements, if you satisfy the requirements for a contract, it is valid vis-a-vis the parties themselves. But the courts are not bound by these agreements, so they, to adopt your words, they will not slavishly follow the provisions in these agreements, and they will always use their discretion, and they may consider it, they may look at it and take into account that, perhaps that was the intention of the parties, but they're not bound to follow it. And at the end of the day, it's up to the courts in using their discretion.
Right. Has there been any sort of seminal case that's revisited this recently in Malaysia, Malaysian law, or is this something that we are sort of waiting for to happen in Malaysia, a case that actually confront this whole issue of nuptial agreements?
I think we're still waiting for that seminal case.
Right, right, okay. And then moving on in terms of the asset protection and succession planning. So here we have the case where we're looking at Richard creating a trust in Labuan of his investments in mainland Malaysia or Peninsular Malaysia. And the question asked is, can Richard actually create a trust in Labuan using property located in Malaysia? So obviously in the fact pattern, Richard is resident, domiciled and citizen of Malaysia. And here he's putting assets, in this case investments, he'd be putting that into a trust established in Labuan. Now, is this actually possible?
It is possible, but Richard would require the prior approval of the Labuan Financial Services Authority first, before he can put those property into a Labuan Trust.
And that sort of authorization process, what's actually involved in that from a procedural standpoint for Richard? Well,
just very briefly, when you set up a trust in Labuan, you do have to make use and appoint a Labuan Trust Company as one of your trustees. So most of the time, these applications would go in through this Labuan Trust Company that's a trustee, making a written application to the Labuan Financial Services Authority, just seeking the approval. And these approvals are given.
Right, right. Have you ever come across an approval that was, an application that was denied or rejected?
I've not personally come across one that was rejected.
Right, right. Okay. And the timing of this approval, how long does it generally take before the sort of applicant can expect this?
Well, I mean, the usual bureaucracy is there as always, but I don't imagine that it would take that long. I seem to recall that perhaps in a week or so.
Right, right, okay. And looking at the fact pattern again, what we have here is Richard transferring his BVI company shares into the trust established in Labuan. And the question here is, can Richard create a trust in Labuan using foreign property, BVI company shares?
Yes, absolutely. I think that's the main intention where Labuan trusts were concerned when the whole concept and the legislation was introduced in 1996.
And is there a requirement for authorization in this case?
No, not at all. You can do it automatically.
Right, right. Okay, so that's the key distinction. Is
yes.
when you have a sort of domestic Malaysian creating a trust in Labuan, it's only authorized where you have domestic property being put into that trust.
That's right.
And just as an aside, can you put Malaysian land into a Labuan trust?
Sorry, I was just going to say, Malaysian land or other property in terms of shares, they'll be treated the same way. You'll still need authorization from the Labuan Financial Services Authority.
Right, okay. All right, so looking at domestic divorce. So this is the case where Richard and Isabel begin divorce proceedings. Key issues here are grounds on which Malaysia Divorce Court will exercise jurisdiction to grant a divorce, and is Malaysia Divorce Court bound to enforce the terms of a pre- and post-nuptial agreement? So the key one here is, I guess, the basis on which the court will exercise its jurisdiction to grant a divorce. So when we've done this previously, we've looked at different nexuses that the courts will look at in the other jurisdictions that we've sort of canvassed on these virtual round tables, and some of them look at residency, habitual sort of abode. What's the nexus that Labuan, that Malaysia will apply when exercising its divorce jurisdiction?
There's a requirement that both parties must be domiciled in Malaysia. So that's the general requirement. There are exceptions. So for example, if the husband had deserted the wife or been deported from Malaysia, for example, and the wife had been resident in Malaysia for 2 years prior to commencing divorce proceedings, the court would also take jurisdiction in those circumstances.
Right.
And sorry, just to add an interesting thing, because I was talking about domicile, it's also actually provided in Section 3 of the Law Reform Marriage and Divorce Act 1976, that if you're a citizen of Malaysia, then by law, you're deemed to be domiciled in Malaysia until the contrary is proved.
Right. Okay. So that can, that will lead to some interesting variations. I think that there's a similar provision in the Singapore equivalent, where they also deem you to be domiciled by virtue of your citizenship as well. But it can be rebutted, obviously. I think we discussed the nuptial arrangements, and here we're still awaiting a sort of case that decides whether or not what weight the courts will put into nuptial arrangements, whether or not they're just persuasive or they'll follow them to the letter.
I should just follow up as well, Zach, to make it clear that the Law Reform Marriage and Divorce Act only applies to non-Muslims.
Yes, that's right.
Yeah. So you're talking about Muslim marriages, etc. That's not part of our discussion today.
No, correct. That's right. Now, with respect to the trust established in Labuan, there are a couple of questions on this. Can a Malaysia Divorce Court make an order varying the terms of a Labuan trust, and can a Malaysia court set aside the transfer of assets into a Labuan trust? So I suppose the first question is premised on, obviously we've got some of these matrimonial causes acts that have been circulating within Commonwealth jurisdictions, and they provide for what they call sort of nuptial settlements. And within that, the court has discretion to vary nuptial arrangements, nuptial settlements rather. The first question, I guess, is within the Malaysia sort of Matrimonial Causes Act, do we have the concept of a nuptial agreement or a nuptial settlement? And if we do, does it provide for the court having power to vary that in the context of a trust? And then looking at Labuan particularly, because it has very sort of advanced firewall protections around Labuan trusts, whether or not a divorce court in Malaysia would be troubled by any of these sort of protections because it's effectively within the same country or jurisdiction. And then obviously looking at the whether or not any of the transfers into a trust, in this case Labuan Trust, could be set aside if they were done for reasons of trying to frustrate a divorcing spouse. So that's usually the context in which these questions are asked. So I just invite you to comment on both of those.
Yeah, I mean, the main provision that we need to look at is obviously Section 102 of the same act that we've been talking about, the Law Reform Marriage and Divorce Act 1976. And in that section, very clear powers are given to Malaysia Divorce Court, whereby they can set aside disposition of property within 3 preceding years if it can be shown that the object of that disposition was really to, reduce the means to pay maintenance or to deprive the spouse of a share of that property. So under those circumstances, a Malaysian divorce court is given power and has the powers under this section of that act to actually set aside that disposition. And before the disposition actually takes place, there is also power under the same provision for an injunction to be given by the Malaysian Divorce Court. Of course, you need to satisfy the requirements in order for the injunction to be given. And if you do, then the court can actually prevent the intended disposition of property in such a situation. I think when it comes to varying the terms of a Labuan Trust, that's slightly different because that's a lot wider when you're talking about varying the terms. I mean, if it's to do with the disposition, then they can do that. But varying the terms, not sure that the powers of the court go that far actually.
Right. And because if it happens, let's say the disposition was made more than 3 years before the divorce proceedings, then they would be thrown back on whether or not there is power to vary the trust.
I mean, if it's more than 3 years, then I think very clearly there wouldn't be.
Yeah. Okay. All right. And moving on to, would a Malaysia Divorce Court seek to make an extraterritorial order dividing UK property, and would UK court recognize and enforce a Malaysian court order in those circumstances? So do the Malaysia Divorce Courts actually habitually make extraterritorial orders as a matter of practice? I
think they could, because I mean, they have jurisdiction over that couple, and in granting a divorce, they have the full powers under the Act. But I think it's more whether in reality, in practical terms, whether there's any effect at all of making such an order, because we are talking about, as you said in your question, an extraterritorial order. So, it's going to be a Malaysian court issuing an order. The question would then be, would the UK courts recognize such an order? And it may not necessarily be so. And in any event, I don't think it will be automatically enforced. No. Because it's not the same as something like a reciprocal enforcement of judgment, which has its own rules. And this is a lot more complicated than that, because it's not a judgment sum. So I think in reality, there would be no force of any such order as such in the UK. So in theory, perhaps, but in practice, I don't think it would actually be carried out. But then, of course, the other way of looking at it is that if the parties are within the jurisdiction of the Malaysian court, then if one of the parties is not abiding by it, and perhaps there's a situation of perhaps holding that party to be in contempt, etc. But not in terms of going directly and having it enforced in the UK.
Yeah, no, I'd agree with that. I mean, the relevant Administration of Justice Act 1920 would be the relevant linkage with the UK, and there it would just effectively apply to a money judgment. So they generally wouldn't get involved in a sort of personam action where it's involving divorcing spouses. So I think you're probably right. As long as, let's say, it's Richard that's trying to do this, remains in the jurisdiction, then I think it will be a direct order against him to transfer the property as in part of settlement of the divorce proceedings upon pain of sort of contempt of court and prison. Okay. So, looking at the domestic succession. So here we have Richard passing away, And there's a number of questions that we'll run through. So basis of application of Malaysia's succession laws, and this is immovable property versus movable property. And again, we just say the same thing again. This is a non-Muslim couple. Okay, so we're not applying Sharia law. We're looking at a non-Muslim scenario. Does Malaysia's succession law include forced heir rights, as we would understand it from a civil law perspective? Can a dependent make a claim against the estate? And is there any inheritance tax in Malaysia? So the basis and application of Malaysian succession laws as they apply to immovable property and movable property. I could ask your opinion on that, Kim.
Yeah, with regards to immovable property, it would be lex situs, which is the law of the land where the property is situated. And in terms of movable property, then it's back to domicile, right. that concept that we talked about earlier for marriages. So it would depend on the domicile of the person in question. So if that person is domiciled in Malaysia, then Malaysian succession laws would apply to the movable property. Then the immovable property will be wherever those immovable property is situated. There is, of course, no forced heirs laws rights under normal Malaysian civil law. And the whole concept of forced heir rights only applies to Muslim marriages and Muslim sort of succession provisions. So that's not a concept that is applied to non-Muslims in Malaysia. Your third question, yes, there is a provision in Section 3 of our Inheritance Family Provisions Act 1971. So if in a will, the deceased, Richard in this case, has not made provision for either his wife or his son or daughter, they can make a claim against his estate for maintenance.
Right.
And the last question is, no inheritance tax in Malaysia.
Right.
Unlike in the UK, which is very high, I believe.
Yes, yeah, that's correct. Okay. I think just looking at the UK, the follow-on questions is which succession law will apply to UK stocks and investments, Malaysia or UK, and then which succession law will apply to UK land, Malaysia, and will a grant of probate administration be required? And is there any UK inheritance tax implications? I think we'll look at it from the context of, let's say that Richard were to die without a will. So he was dying, let's say, intestate. And insofar as the UK stocks and investments, they would pass by way of Malaysian intestacy law, because Malaysia would effectively control through the domicile of Richard the succession to movable assets, and stocks and shares would be classified as movable assets for those purposes. Now, with respect to UK land, let's assume that Richard died intestate. It would be UK intestacy rules that would apply, because it would be the situs. That would be the relevant law, and it would be obviously UK law being applied. Insofar as a grant of probate or administration is required, then obviously Malaysia and the UK are both Commonwealth countries, and there would be what's called a simple resealing. So effectively, the Malaysian grant would be resealed in the UK, and there wouldn't be a requirement to go through the formal process of applying again in the UK. For inheritance tax purposes, then within the fact pattern, Richard was not UK domiciliary, neither was Isabel, so therefore the main attachment for inheritance tax in this case would be the situs of the absence, and that's the land and the stocks and shares. Applying the UK normal sort of provisions on inheritance tax, that would be the only property that would be subject to coverage. In other words, Richard's worldwide estate would not be within tax for the UK inheritance tax net. It would just be assets situated in the UK. And of course, the normal exemptions and exclusions would apply. So moving on to the foreign case study. We're looking first at the immigration side. And this is the fact patterns here are Peter is a resident, domiciled, and citizen of Hong Kong. Married to Winnie and has a child, Jin, son. Has various assets in Hong Kong, including a trust of investments and land. The fact pattern is that Peter moves from Hong Kong to Malaysia, and at the same time creates a trading company with a trading subsidiary in Hong Kong. So trading company in Labuan, in this case, with a trading subsidiary in Hong Kong, and holds an investment account in Singapore. Other assets are acquired once taking up residency in Malaysia, including a house and a depository account. So the questions that will be asked from an immigration standpoint is the process and requirements to establish a Labuan business, the director residency requirements, tax implications of setting up in Labuan, and then the Malaysia residency rights that flow from establishing a presence in Labuan. And I would invite Farah to just take us through first the process and requirements to establish a Labuan trading entity.
Thanks, Zach, and hi everyone. Nice to see everyone here today. It's really quite simple. Setting up a business in Labuan, what you need to do is go to one of our 60 trust companies, submit the requirements. It should be done within a week. There are different thresholds for incorporation, obviously, and the statutory fees. But all in all, based on experience and depending on the type of service provider that you engage, it can cost anything between $2,000 to $4,000 US to set up a Labuan company. Yeah, it will take about a week or so. You can fast track it if you want. There is a fast track requirement, a fee for it, but that's very minimal. And really what that gives you is the ability to have a Labuan company in order to run your business out of. These trust companies or the company secretaries that we have in Labuan, they have offices in KL, they have offices in Kuala Lumpur, they have offices in Singapore, offices in Hong Kong, and I'm sure they've got referral partners around the globe. So if you are interested in a Labuan company, if they don't offer it automatically on the menu, you may ask for it, and they will have referral partners in order to offer that to you. There are no director residence requirements. It's not mandatory to have a domestic director. So you could be 100% foreign. It doesn't have to be a Malaysian. Any Malaysian directors are not required, okay? The tax implications have become a little bit more complicated in the sense that the 3% tax is now applicable, and there are substance requirements that are now required. So you need to employ 2 full-time employees, paying them the minimum wage, the minimum Malaysian wage, which is about $350 US, depending on the level. And you need to have a domestic spend of 50,000 ringgit, right? For Malaysian residents right now, this is when it gets a little bit more interesting. If you had one of these companies and they this company actually conducts services, trading in services, you are then able to get residence rights in Malaysia. The original immigration allowance will be for Labuan, but that can be extended to any place in Malaysia, and that also includes spouses and dependents. So in a way, the Labuan company not only gives you that tax neutrality, it can, for the right kind of companies, also offer residency.
Farah, just on the substance, because this is obviously the big all the rage nowadays.
Yeah.
What's actually required in Labuan itself? Because we've got this requirement to employ at least a minimum of 2 individuals in Labuan. But what about the offices and the premises, etc.? What needs to be shown on that, if anything?
So it can be outsourced. Well, I know for a fact that a lot of the Labuan corporate service providers are at the moment offering offices, shared offices in that sense. So you can have an office. At the end of the day, it is about the domestic spend. It is about having 2 full-time employees in Labuan, one of which has to be a managerial capacity. And that really is the requirement. I mean, I think what's worth noting, aside from just this immigration issue or the limiting, the circumstances surrounding the case we're discussing at the minute, is the fact that the Labuan substance approach is fundamentally different from other jurisdictions. So we've been very prescriptive in that sense. Prescriptive in this sense, it's a word that is negative, but not necessarily in this instance, because there is certainty. There is no reference to adequacy necessarily in the way we have approached it. So there is a laundry list of structures and solutions, and for that laundry list, you have corresponding requirements for full-time employees and domestic spend. And just to remind everyone here that the domestic spend includes everything from the amount you pay your secretaries, the amount that you spend for board meetings, the regulatory fees that you pay. So anything outgoing from the Labuan entity is deemed a domestic spend.
Right. And insofar as in our fact pattern, we've got Peter, and presumably he's going to be a director of the Labuan company. Does Peter actually have to hold his board meetings in Labuan itself, or is there a requirement that it's seen as a sort of mind and management occurs in Labuan?
Very much mind and management. Peter himself does not have to reside in Labuan, and it's very much management issue.
No,
Your microphone's still on, I'm afraid.
Kim, your mic's still on.
sorry.
Yeah, sorry. So we were just looking at Farah. We were just looking at the directors, whether or not, in our case, Peter actually has to go to Labuan to
Yes,
do
evidence, mind and management. Yes, he will have to go to Labuan.
Right, he will have to go to Labuan, but he doesn't necessarily have to live in Labuan. I think
He does not have to reside, but he needs to be able to prove that mind and management, the decisions, the executive decisions that he has taken on behalf of that company is executed in Labuan.
Right. So how does this work now in a COVID environment? What has there been anything that we've done in the meantime where the travel restrictions have been in place?
Yeah, so very much like other jurisdictions, what has happened is that the Labuan Financial Services Authority has passed on some regulatory relief, which is still in place because of the limitation vis-a-vis travel. It's as simple as that. I mean, it's box standard. All the other jurisdictions have done it, and so have we. I would suspect, and again, the disclaimers coming out now, but I would suspect that, for as long as we've got this pandemic ongoing, for as long as the travel bubbles are not clearly defined or executed, and the situation still remains in flux, which unfortunately it still does, these requirements will continue to exist. And this relief, sorry, will continue to exist.
Right. And then finally, for Peter, he gains residency rights by virtue of his Labuan trading entity. Could he reside anywhere in Malaysia with those rights, or is he earmarked for a particular state?
Yeah, so this is the thing. First and foremost, the immigration will allow for him to reside in Labuan. Then a further application and endorsement will be required for him to be able to reside anywhere in Malaysia, number one. So for all intents and purposes, Peter could reside in Johor Bahru,
Right.
or Penang, or Langkawi, which is beautiful. But also what's important is that Peter is able to have his spouse and his dependents with him.
Right, right, okay. Is there a pathway to citizenship through this route?
Unfortunately not. Malaysia is extremely, extremely careful who they even give permanent residency to. So foreign spouses, it's not easy to get, number one, and passports or nationality is almost unheard of.
Right, okay. Well, on that positive note, we'll move on. Looking at the succession planning, this is a simple case. All we have is Peter transferring his investments in Singapore into a Singapore trust. And I pose it just to ask a simple question. Is there any Malaysia tax consequences for Peter engaging in this type of succession planning or estate planning? I'd invite Kim to help us with this.
Yeah, that, as we mentioned earlier, there's no inheritance tax. So there is no tax that applies when he's transferring his offshore assets into Singapore. And the other thing to note as well is that in Malaysia, we don't have corporate gains tax or capital gains tax unless we're talking about real property.
Right, right.
So the main tax we have is really just income tax.
Right, and insofar as the income that used to accrue from these financial investments would be to be liable both before, in terms of the income stream before he put it into trust, and would there be a difference when he puts it into trust and the income stream no longer goes to him? Is there, what's the analysis from that perspective?
If he had received income before, then obviously he would have been subject to income tax. But Malaysia's income tax laws is based on territory. So only Malaysian source income is subject to tax in Malaysia. So if you hold, shares in the UK or Singapore, you won't be taxed on dividends from those shares. So
if they're remitted into Malaysia, is that right?
Even if you remit it into Malaysia, so foreign source income is not taxed in Malaysia.
Even if it's remitted in?
Even if it's remitted in, yes.
Okay.
Yeah. So our income tax laws are quite generous where that's concerned. And of course, when it goes into a trust, and depending on the terms of the trust, if he's not paid any income from the trust, there's no question of tax.
Right, right, okay. So looking at the divorce law implications, because obviously in this case, Peter and Winnie they're not original Malaysian domiciliaries, they're residents of Malaysia. So we're looking at the basis on which Malaysia court would exercise jurisdiction where we have visa residents. And then would a Malaysia court enforce a Hong Kong pre or post nuptial agreement? So basis on which would a Malaysian court effectively exercise jurisdiction where we have a visa holder? How would we sort this one out?
Again, it sort of flows back to the original requirement of domicile. And as I'd mentioned earlier, we do follow the English common law on the whole concept of domicile. So you have domicile of origin when you're born, and in the case of Malaysia, there's a specific provision that if you're a citizen, you're deemed to have a Malaysian domicile. And maybe to explain it in a non-legal way, domicile is actually very different from nationality. It's more the concept of a place where you consider to be your permanent home.
Mm.
So your domicile origin, if you're born in Malaysia as a citizen would obviously be Malaysia. But then if you decide to immigrate and set up a permanent home elsewhere, could very well be that you then shed your domicile origin and then pick up a domicile of choice, which could be Australia or UK, going by the examples that we had talked about earlier this afternoon.
Right.
And there's also another concept if you're a married woman, which is the domicile dependency, whereby a married woman takes the domicile of the husband. So that's just very briefly how domicile works. So in this case, it will depend very much on whether the couple can show their intention to make Malaysia their permanent home, to the extent that it's clear that they've established a domicile of choice in Malaysia.
Right, right.
Before the Malaysian Divorce Court will exercise jurisdiction.
Right, right. And then if in the case that they do demonstrate that they have a domicile of choice in Malaysia, and they've demonstrated enough sort of commitment to staying in Malaysia permanently, would a Malaysian court entertain effectively a Hong Kong nuptial arrangement in coming to exercise their discretion? We talked about this before in the context of a domestic couple, but given that the marriage was, let's say, celebrated and is originated in Hong Kong, would it hold any sort of more weight that it's a foreign marriage with respect to the Malaysian court?
I don't think it necessarily will. I think the Malaysian courts will still go by the laws in Malaysia, and in particular the SAME Act, the Law Reform Marriage and Divorce Act of 1976, and look at what the powers are given to the courts under that act. So the courts will have full discretion, but they are not bound to pay heed to or apply any pre or post nuptial agreements agreed between the parties.
Right, okay. Okay, so looking at the Hong Kong land, the property, whether Malaysia Divorce Court may order division of a Hong Kong property, and whether the Hong Kong court will recognize and enforce. So we did this in the context of the UK. So we're again sort of looking at it extraterritorially. Any views on, insofar as a Hong Kong based property in Malaysian court, from what you said previously on the UK side?
I don't think there'll be any difference, regardless of whether the property is in Hong Kong or UK. The concept would still be the same, and the it's a, in actual fact, it will not have the effect that is desired because it's extraterritorial. So it will still very much depend on the court in the jurisdiction of where the property is held, in this case, Hong Kong.
I think Hong Kong has this enforcement of foreign judgments, and in that they do have a section where they will not enforce matrimonial related sort of orders. So I think that's pretty clear from their perspective that they probably would not entertain money related order, particularly one stemming from divorce proceedings. Now, insofar as the, so whether a Malaysia Divorce Court would seek to set aside dispositions of assets into a Hong Kong trust, and whether a Malaysia Divorce Court would seek to redistribute Labuan Company shares, and whether a Malaysian Divorce Court would seek to set aside disposition of assets into a Singapore trust. So these are looking at, from the sort of matrimonial causes perspective, whether or not sort of assets were put away with the intention, presumably on the trusts, of frustrating, in this case, let's say, Winnie's claims in the divorce proceedings. So I think from the Hong Kong and Singapore Trust, would a Malaysian court seek to set aside those dispositions on an extraterritorial basis?
I think the answer to that is, technically they can, because under the Section 102 that we mentioned earlier of the Law Reform, Marriage and Divorce Act 1976, the powers are given to the court to do so in a divorce if they can see that this was done in the preceding 3 years. The intention was to really deprive the spouse of a share of the property or to reduce the means for maintenance. Then the court does have that power. But again, the stumbling block is the fact that we're talking about assets which are outside the jurisdiction. In this case, whether it's in a Hong Kong trust or a Singapore trust, the Malaysian court, in actual fact, will not have the powers to go across territory to either Hong Kong or Singapore to have whatever order that they may give in the Malaysian court to be enforced.
Yeah.
So that's the main issue. That's the problem.
Yes, and that's coming back to the nuptial settlements issue.
Yeah.
From a standpoint, they have the nuptial settlements, but as I understand it, Malaysia doesn't have within its matrimonial causes the same issue of nuptial settlements being subject to variation. Is that correct? Right. But surely they would be able to redistribute the Labuan Company shares.
Yes, that one, the answer to that is yes, because the Labuan Company is within Malaysia. Labuan is still part of Malaysia. So the assets in the form of shares in the Labuan Company would be Malaysian assets that they can give an order to redistribute in any way that the court deems fit, and it can be enforced in this situation.
Right. Okay. So just looking at the succession law implications. So here we have Peter passing away, and the question being asked is from a Malaysia domicile perspective, dependent claims against the estate in Malaysia, basis of those, dependent claims against property in Hong Kong. So we're looking at this from the clawback claims against trusts in Singapore and Hong Kong. So we're looking at it in the context that if it were found that Peter at his death was Malaysian domiciled, So in this case, you would clearly be a Malaysian domicile of choice, unless he had an origin, oddly enough. Would there be a dependent claim, could there be a dependent claim against the estate in Malaysia? And then with respect to extraterritorial claims, dependent claim against Hong Kong sort of property, and then clawback claims against the trusts in Singapore and Hong Kong. Is it capable of, are we capable of having clawback claims within the context of the Family Provisions Act in Malaysia?
Yeah, the answer to one is yes, as discussed earlier. So yes, the dependent can make a claim against the estate in Malaysia. Now that Peter is been shown to be domiciled in Malaysia, so the courts will have jurisdiction, and the courts can order maintenance against the estate for either the spouse or the child that's not been provided for. The second point, again, you have problems with extraterritorial.
Yeah.
So I think that, that is really a no-go.
Yeah.
I would imagine.
So that particular one, Kim, it seems that when Commonwealth jurisdictions have all been running this piece of legislation, these family inheritance dependent claims, and what there seems to be a sort of common view that they won't exercise discretion where it's land. They don't mind exercising discretion where it's movable assets. But insofar as land is concerned, they say that that's a situs issue and not covered by their discretion. And there's a bunch of authority on this from New Zealand and Australia, where there's a reluctance to exercise the family provision sort of extraterritorially when it's dealing with real property, immovable property. I think probably if sort of Malaysian courts would probably prefer to Commonwealth's judgments on these and see what the other courts are doing, they may well take the view that it's Hong Kong land and therefore it's off limits for us to exercise a discretion on a situs asset. I mean, what do you think about that?
Yeah, I think you're quite right, because the decisions in other Commonwealth courts will be taken into account, persuasive to a Malaysian court, especially when there are no Malaysian court decisions on the same point. Right. So yeah, those decisions would be persuasive to a Malaysian court in terms of how they make the decision.
And in terms of clawback, am I right in my analysis of the Malaysian family inheritance legislation is it doesn't have a concept of clawback? Is that correct? Yeah,
it doesn't have the same provision as set out in the Law Reform Marriage and Divorce Act, which basically gives the right for either an injunction or a clawback, as you say, in regard to disposition.
Right. Okay, and then looking at it from the Hong Kong perspective, I can run through this fairly quickly. Hong Kong operates in the same way in terms of entitlement, where the Hong Kong court will have discretion where the deceased died domiciled in Hong Kong, but they also have this extrapolation where they're ordinarily resident at any point in the 3 years prior to death. That would also give the Hong Kong court rights to exercise their discretion. So a dependent claim would be possible if Peter had died within 3 years of having been Hong Kong ordinarily resident. Dependent claim against Malaysian property, you would have a clear conflict here because Malaysia would be operating on domicile basis, whereas Hong Kong in this case could be operating on a deemed basis because of the ordinary residence. And in any event, even if the Hong Kong court wanted to do it, I think it would probably not try and move against Malaysian land. If it were going to try it, it would be against Malaysian movables. But given that the Malaysian court has authority through the domicile, it's very unlikely a Hong Kong court would go against, would effectively make an order where it had no chance of being enforced. And in clawbacks, yes, you do have the right within the Hong Kong setting to claw back if there was within 6 years there was a disposition that was seeking to defeat any of these dependent claims. I think that would be possible against the Hong Kong Trust, but not against the Singapore Trust, because the Singapore firewall protections would probably apply. Okay, I think that brings us to the end. I think we've run over a little bit, but in terms of questions, we've got a number of them lined up, and we'll see what we can do for, let's say, the next 15 minutes. let's see, I'm just going to go. So does a Labuan Trust need to fulfill the substance requirements? I think that's fair. That's one perhaps, and also obviously Kim, does a Labuan Trust need to fulfill substance requirements? Is it within the substance requirements?
It's silent.
Silent, right.
Well, I was going to say the short answer to that is no, but then Farah is more circumspect than me.
Right. Okay. So it's not.
Yes, yes. It's silent, and in this and the same would apply to a foundation as well, right, Kim? So,
well, talking purely from a legal perspective, and not Farah being the regulator has got her hands somewhat tied. You know, I would say that you go strictly by, you know, what's written in the law, and if there's nothing in the law that talks about substance, and there's nothing, you know, in terms of requiring it, and in the same way that regulations have been brought in for companies, I would say that you just go by what's in the law, and there's nothing in the law. So I would take it that there are no requirements.
Right, right. Is that likely to change? Is there any mutterings of a change on that?
I think the concept of a trust is very different from the concept of a company. So I think if you're a company and you're trading and carrying on business, it makes a difference to show that you are actually carrying on business from the jurisdiction where you say you are located. But a trust is, the whole concept of the trust is so different. You're not carrying on any business. You know, your trustees, besides the fact that you must have one trustee in Labuan under the Labuan Trust Act, your trustees can be anywhere. Your decisions can be made anywhere. And you know, there really is no requirement or reason why you actually need to be situated in Labuan.
Right, right.
That's my take on it.
Okay.
and also just to add and put my neck out there a bit, other jurisdictions do not require for substance anyway for these structures. And
Yeah, that's true. That's
so
true.
there's no reason to assume that we would either.
Yeah, yeah, that's true. Okay, insofar as a dispute involving a Labuan structure or a Labuan company, which court will handle the matter? So this is one of the questions. Which courts will have jurisdiction to hear Labuan sort of disputes?
Labuan is in a bit of a unique situation because if you know the history of Malaysia, we have East Malaysia and West Malaysia. So in our court system, we actually have a High Court of Malaya, which is West Malaysia, and we have the High Court of Borneo, which is East Malaysia. So Labuan is actually situated in Borneo, East Malaysia, but it is not part of East Malaysia in terms of administration, because it's been declared a federal territory. Previously, it was part of Sabah, which is one of the states in East Malaysia. So it would be very clear that, you know, the High Court of Borneo would take jurisdiction. But in this case, Labuan is in a bit of a unique situation. But I think the fact that it's there in Labuan, you can have the High Court of Malaya, which could sit in Labuan to hear this case, so that it would still be the High Court of Malaya on the basis that Labuan is a federal territory.
Right, right. Okay, and then there was another question with regard to, which is transfer of properties investments. Apart from the Labuan approval, will the foreign exchange rules of BNM be applicable? So I think this is coming back to authorization for a domestic individual to transfer assets into a Labuan structure. Is there any other approvals that are required?
I think that, well, Farah will jump in, I'm sure, but I think the unique position of Labuan in the Malaysian foreign exchange system is that if you set up a company in Labuan, you are considered for purposes of the Bank Negara foreign exchange rules as being a non-resident. So because of that, you do not require the approval of Bank Negara the way that a resident would do in relation to a lot of foreign exchange transactions. So Labuan has been given this special dispensation that they're not treated like residents of Malaysia.
Right, okay. And then I think one for me, in terms of the 6-year clawback. So the context in Hong Kong was you have an individual dying and you have a dependent claim against the estate. Hong Kong provides a rule, which is the same as the UK, where you can revisit dispositions into a trust that occurred in the 6 years prior to death. And that's the same both in the UK as well as in Hong Kong. So that's just explaining, but you need to obviously prove grounds for revisiting that disposition if it was done with the intention of defeating claims, dependent claims. This is not something that's capable of being done either in Singapore or in Malaysia because they don't have the clawback provisions. Another one with respect to the UK, the tax implications, the only point being made was if you're non-domiciliary in the UK, then it's the UK cited assets that will be subject to the inheritance tax, and the applicable rates and exemptions, etc., will apply in the usual way. It won't apply on a worldwide basis. So unless you're some way deemed domicile in the UK, then you'll start to get into trouble. But if you don't have a domicile connection with the UK, then the inheritance tax will just be on a citus basis. But there are special categories of assets that are carved out of that insofar as investments are concerned. So you need to look and apply the rules in a particular way. Now, anything else? Let's see. I think we've also got some questions on the chat. So I'll just take a look at that and we'll. So give me a second just to read through. How do the current tax law systems affect the mobility of funds from those intent to domicile other countries? No, this will be something. This is on a CRS question, so no. So when all property is owned by a foundation in Labuan, then what is the right of a wife if the wife is not beneficiary in case of divorce? So there we're looking at, presumably we'd have to make up a bit more of the fact pattern here. Let's assume that we had a domestic divorce and there was a foundation in Labuan. If the wife is not in any way connected, not a beneficiary, etc., then Kim, are we getting back to this same situation of being able to effectively set aside dispositions where we can prove that they were being made for the intent of frustrating a divorce court?
Yeah.
Right. And that's notwithstanding any of the professed provisions in Labuan that seek to limit the ability of those sorts of claims to be made against Labuan-related structures.
I think the ones that you're referring to is when we're talking about trust, which is Section 10.
Yeah.
But strangely, that only talks about foreign. So it doesn't talk about, Malaysian.
Yes. Do we have the same provision under the foundation where it says, without prejudice to any Malaysian laws, when it comes to the protections? Does it have the same sort of proviso?
I can't recall offhand, actually, whether it's exactly the same in the Labuan Foundations Act. Right.
Okay. I mean, just one final point on the trust side when it comes to these divorces. There's always sort of case law on this where if you do have an aggressively drafted trust where the settlor reserves numerous powers to revoke, powers of appointment, then don't be surprised if a divorce court doesn't view the trust as simply being a piece of matrimonial property. So they wouldn't even trouble itself with looking at trying to apply some of these clawback rules or looking at setting aside dispositions. It would just see the trust as effectively an asset in the estate. And I think we've seen cases, there's a case in Singapore in the early 80s where that exact same thing occurred, where there was an aggressive reservation of powers. And the Singapore court took the view that, well, this is just part of the assets of the estate. These are not separated from the actual sort of patrimony of the parties. So when you're creating aggressive trust structures, bear in mind that these powers that you're reserving may be tantamount to a property ownership in the eyes of a family judge. Kim, would you agree that that sort of analysis could be quite open to some of these family judges?
I suppose it is possible, but I think there is provision in the Labuan Trust Act that actually says the fact that you reserve powers doesn't, impact the validity of the trust, etc. So if it doesn't impact the validity of the trust, that means it's been properly established as a trust, then the protection given to it under the Labuan Trust Act would apply. So, in a sense, that has been covered by legislation.
Yeah. I suppose you could run a similar argument, I think we just wrap up after this. You could run a similar argument where you're trying to do a dependent claim and you're faced by a trust and there's no sort of clawback, but you can say, well, there's so much reservation of powers that effectively this is property in the estate. So I don't need to actually look at a clawback. This is actually assets that are available in the estate. I mean, these are arguments, whether or not they would meet any sort of success, but at least you can assert that.
Yeah, yeah, sorry.
Sorry, I'm peaked now because, sorry, if you know what I'm like, if at the end of the day, right, a founder has endowed and given up all rights of a piece of property to the foundation is the legal owner of this entity, how can a wife then create a nexus to that foundation when there has been legal transfer of benefit and ownership through an entity with a separate, I mean, in that sense, we're going into that whole idea of trust versus foundations, that whole piece of work.
But isn't that just the clawback, Kim? Isn't that just going to be the court exercising its statutory rights to claw back the asset in those circumstances?
If it applies to because we're talking about different legislation, Farah, we're talking about the powers given to the court under the Law Reform Marriage and Divorce Act, which is specifically to prevent steps taken by a spouse to deprive the other spouse of either a share of the property or to reduce his means so that he doesn't have to pay maintenance to the other spouse. So that provision is put in there to prevent the spouse defeating the court's ability to divide and to order maintenance, etc., in a divorce. So to prevent that, so they have this clawback that says if you did it within 3 years before divorce proceedings were commenced, then of course you have to satisfy the court, prove to the court that yes, it was a very clear-cut case that the only reason why this property that's been in the family for 20 years was suddenly disposed of. Then once the court is satisfied, then the court has the powers to order such clawback of properties. So that is the background, the scenario to approach this. And the corresponding thing then is look at whether the Labuan Trust Act or the Labuan Foundations Act has a firewall, as the Ways Act puts it, to prevent it. And we had looked at the Labuan Trust Act. And in that case, the firewall only talks about foreign jurisdictions. Claims from foreign jurisdictions will not have any traction against a Labuan Trust. But there is a provision in that section right at the end that says when it comes to Malaysian laws, it only applies if it's consistent with the rest of the laws of Malaysia. So that is the difficulty there is. And since that is already put into the legislation, and the Labuan Trust Act is obviously a later piece of legislation than the Law Reform Marriage and Divorce Act, which is 1976 versus 1996. So then you would deem that the draftsman is aware of that earlier act, but still drafted it the way he did, which must mean that he's taken cognizance and he's trying to make sure that the act can work side by side, so it doesn't render the earlier act redundant.
Right. So I think the lesson learned there is don't try and use Labuan as a convenient jurisdiction to evade your obligations under a sort of divorce court order, because it's not going to work. If you're a domestic Malaysian,
Yeah.
if you're not a domestic Malaysian, it might work, but for a domestic Malaysian, it's not designed for that purpose. I think that's the broad view. All right. Okay, I think we will stop there for today. Thanks very much to Kim, to Farah and Dominic for spending time, and thank you for everybody who spent time viewing this. Very grateful for all the support and everyone who sits and goes through these VRTs with us. And just mention that we've got the governance and succession program, which is going to be kicking off next week. But for today, I think this is sort of thank you from us all, and thank you to the panelists for spending time. Okay, thank you very much. Bye.